Welcome students to the class of intellectual property rights. Today we are going to discuss with Semiconductor Integrated Circuit Layout Design Act 2000. So let's start. This act, that is the Semiconductor Integrated Circuits Layout Design Act 2000, gives a recognition to the layout design used in semiconductor integrated circuit. It came into force on 4th September 2000. And the exchange of information worldwide has become very fast, and we can store the data because of this semiconductor integrated circuits, or we can call it as simply it is called as chips. Now they help us in all the way in our day-to-day life, whatever we do. As far as technology is concerned, integrated circuits help us to store data and to transmit, to exchange the data from one place to another. Chips are often called as the crude oil of the information age. Now, integrated circuit consists of 3 layers. One is called as a wafer, which is a thin, highly polished silicon crystal disk of semiconductor material, which is coated with a layer of silicon oxide and insulator, and the electronic components, for example transistors, are formed by a process of diffusion, that is chemically doping the semiconductor material with impurities through holes etched through the oxide. Finally, an aluminum coating is applied, which is partly evaporated using a mask, leaving behind the interactions between components formed in a semiconductor layer. So a chip looks like this. Okay, so there are so many parts. It has got so many parts. It has got a silicon chip here. You must have already seen it when if you go to any repair shop of computers, mobile, you can see this kind of integrated circuits when they do some repairing. You might have seen it. That is called as, that is the core of that particular device. It controls everything. So I'm not technically that sound to explain all these things, but let us try to understand it. Let's go ahead. A chip typically has 8 to 12 layers. Each layer is having a unique mask, creating the required circuits. These layers of masks, collectively called as mask work or layout design, which is the subject matter of this particular act. It is a chip's layout or 3-dimensional organization that requires protection. Layout design of integrated circuits. Now this is how it looks like. As I have already said, I am not technically sound to explain all these things, but together we will try to understand it or try to learn something from that design. Now this is what is called as that chip, integrated circuit chip, and this is how it is designed. Layer by layer they design it, and then on top of it you can see this circuit which is interconnected in between, and then the circuit is over. It is complete. Now these kind of motherboard are usually found in computer CPU, central processing unit, where everything is controlled by that particular CPU, and then whatever data you provide to the computer, it gets processed through this particular motherboard. Okay, you can exchange, you can store the data, you can exchange whatever you want, you can do with the help of this integrated circuit. It's in heart of a device. Okay, chip piracy and need for protection. Now there is a piracy in chips also. That means somebody can steal your integrated circuit design. A layout design of integrated circuits are creation of human mind. It takes enormous investment, both in terms of time and money, to design a new layout design. But a chip pirate can easily replicate the layout design of a chip in few months by removing the chip's plastic, ceramic casing and photographing each layer of the translucent silicon material at a fraction of the original cost. That means you will not be investing a lot of money because everything is already ready-made. Okay, he doesn't have to design. He has to just copy the layers and then join them together to form a integrated circuit, which will be a duplicate one. Okay, so therefore layout design has to be protected because it's a creation of human mind, and that's why integrated circuits have been included as intellectual property. Why do we need protection of IC, that is integrated circuits? Before this act, there were two acts, Copyright and Patent or the Industrial Designs Act, but they did not afford adequate protection to layout designs. So protection of layout design demands more stringent norms of originality than any other intellectual property. Layout designs of integrated circuits are not industrial designs because they do not determine the external appearance of integrated circuits. It's not like a design which is applied to a particular commercial product. It has determined the physical location within the integrated circuit of each element having an electronic function. This is what is called as integrated layout design. Therefore, it was felt for sui generis protection. That means similar kind of protection was needed. Therefore, this act came into force or came into existence. Excuse me. Background of the Semiconductor Act 2000. Protection to semiconductor chips was first given in the United States through Semiconductor Chip Protection Act SCPA in 1984. Japan introduced similar protection in 1985, namely Japanese Circuit Layout Right Act. As per European directives, there was a formulation of 1989 Treaty on Intellectual Property in respect of integrated circuits, which is called as IPIC Treaty, under the auspices of WIPO, World Intellectual Property Organization. The IPIC Treaty was later made part of TRIPS Agreement. TRIPS called for adherence, that is obedience, to most of the substantive provisions of the IPIC Treaty. As a member of TRIPS Agreement, India has enacted the Semiconductor Integrated Circuit Layout Design 2000. The implementation of the Act comes under the Ministry of Communication and Information Technology. A layout design has to be registered to receive protection under the Act. That means what? Layout design has to be registered, then only a protection will be given under this particular Act. What is the subject matter of protection? The Act affords protection to the layout design of a semiconductor integrated circuit. Now you can see this is the design, and it has some kind of meaning. Can you see this? These are the circuits which are purposely made and arranged in certain way so that information can travel or the processing can be done in a particular way. Each circuit, each design has its unique purpose. Therefore, this is done with a lot of intellectual power and intellectual ability. Therefore, its protection is very, very essential. Protection under the Act exists only after the layout design has been registered. Layout design can be registered if they are. Now, these are some of the these are the three essential ingredients for a layout design to be registered under this particular Act. First is it must be original. Secondly, inherently distinctive, and if they have not been commercially exploited for more than 2 years before date of application for registration. Therefore, the Act does not require novelty as in patents, but distinctiveness is very important in case of integrated circuits. Let us come to the first ingredient or requirement. Originality. A layout design normally consists of a combination of elements and interconnections that are commonly known among creators of the layout designs. So they make use of commonly known elements and the way they can be interconnected. But what is protected is how innovative, how creative is your design, how distinct is your design. That is very important here. Next is inherently distinctive. A layout design must be inherently distinctive or inherently capable of being distinguished from any other registered layout design. Probable test of inherent distinctiveness may be function performed by the layout design is new and different from that performed by the other layout designs. Secondly, elements or substances used in the manufacture of the layout design are novel in the industry. For example, certain new alloys. That means the elements which are used in that particular layout design must be newly created, something which has a new feature. Then only it can be said that it is inherently distinct from other layout designs. This requirement of inherent distinctiveness is found in Indian Act only. There is no mention of this kind of condition in any other act in the entire world. So our act is very unique. Third requirement is it should not have been commercially exploited for more than 2 years before date of application for registration. Any act of leasing, selling, offering, exhibiting for sale, a layout design for any commercial purpose amounts to commercial exploitation. If it has been already done earlier, then it cannot be protected under, or it cannot be registered under this particular act. Let's go ahead. Duration of protection. Protection under the act extends to 10 years, which is in line with Article 38(1) of the TRIPS agreement. Under the Indian Act, the date of protection period commences from the date of application for registration in case of layout designs. Now, for example, if a chip was released in the market for commercial exploitation in March 2001 and registered in October 2002, protection would commence from March 2001 for a period of 10 years, that is up to March 2011. Now, what are the exclusive rights conferred by this act on the owner of the integrated circuit design? The registered proprietor has the exclusive right to reproduce by any means the registered layout design or any substantial portion of it. However, there is one significant exception. Any person may reproduce the layout design for the purpose of scientific evaluation, analysis, research, or teaching. This is similar to the fair dealing exception in copyright law. That means any other person can make use of that particular layout design for the purpose of scientific evaluation, analysis, research, or teaching in a class. The Act also allows person to reverse engineer layout design for the purpose of analyzing the layout design and incorporating the insights of their analysis into an original layout design of their own. Such provision is considered to be justified in accordance with Article 6(2)(b) of IPIC Treaty and the provisions in the TRIPS agreement, as there is a need to encourage creativity through the improvement of existing layout design. There was a famous case in the United States Court of Appeal for the Federal Circuit, which has held in case of Brooktree Corporation versus Advanced Micro Devices that a paper trail does not exclusively prove a reverse engineering defense under the SCPA. The court explained that this statute does not excuse copying where the alleged infringer first tried and failed to reverse engineer a cheap layout without copying. The court rejected the claim that the reverse engineering defense can be established by the sheer volume of paper, pointing that the paper trail is evidence of independent effort but not incontrovertible proof of either originality of the end product or the absence of copying. So this was the decision by the court. Next, the registered proprietor also has the exclusive right to import, sell, or distribute for commercial purpose any semiconductor chip products in which the registered layout design is embodied. For example, a watch or a cell phone. Now, not only the layout design is protected, the product in which that layout design is fixed or embedded, that product also gets protected under this act. Now, how a registration of layout design is done? Any person who wants to register his layout design is required to apply in writing to the registrar, Semiconductor Integrated Circuit Layout Registry, in the concerned territorial jurisdiction as per the procedure prescribed in the Act. The registrar, after scrutiny, may refuse the application or may accept it absolutely or with amendments or modification as he may consider necessary. Then there is something called as prohibition or registration of certain layout designs. So some of the layout designs which are objectionable cannot be allowed to be registered. Now let us see which are those. Now this act prohibits the registration of certain layout design. Now, for example, layout design which is not original is prohibited. Similarly, the registration of layout design which has been commercially exploited anywhere else before registration, it will not be protected. Then layout design which is not inherently distinctive cannot be registered. The Act, however, provides that a layout design which has been commercially exploited for not more than 2 years from the date of which an application for its registration has been filed, either in India or convention country, shall be considered as not having been commercially exploited. So it depends on the exception that has been given or provided by this particular Act. Next, withdrawal of acceptance. Now, as per the provision of this Act, the registrar has the power to withdraw the acceptance of an application for registration before registration of the layout design. If it comes to know that the layout design is prohibited of registration under the provision of this Act, the registrar may, however, provide the opportunity of being heard to the applicant. Advertisement of application. According to this Act, when an application for registration of a layout design has been accepted, the registrar is bound to advertise the accepted application within 14 days after the date of acceptance. After the advertisement, the registrar has the discretion to advertise the application again if the application has been corrected or is permitted to be amended under the Act and notify in the prescribed manner. Then, there can be opposition to the registration. Any person under the Act can oppose the proposed registration of the layout design. After an application for registration of layout design has been accepted, any person can give notice in writing to the registrar of his opposition within 3 months. So there are 3 months available to the opposition party from the date of advertisement or re-advertisement or within further period not exceeding 1 month in the aggregate, as may be allowed by the registrar as per the procedure provided. The registrar is required to serve a copy of notice to the application for registration about the opposition. The applicant for registration may send a counter statement of grounds on which he relies within 2 months of the receipt of notice of opposition, and if he does not do so, he shall be deemed to have abandoned his application. The registrar shall send a copy of the counter statement of the grounds to the person giving notice of opposition. Both the applicant and complainant may be heard. They may submit their evidence, whatever they are relied upon, to the registrar if they so desire. Then the registration then decides the matter regarding the registration based on the material before him. The application for registration is treated as abandoned if it is not completed within 12 months due to reason of default. Then comes the registration. So according to the Act, a registrar shall register the layout design in the register if the application has not been opposed within the prescribed time limit, or the application has been opposed and opposition has been decided for the applicant. The date of making the application is considered to be the date of registration of layout design. Then after registration, the registrar issues certificate of registration sealed with the seal of the Semiconductor Integrated Circuits Layout Design Registry. Registration gives exclusive right to the creator of layout design for 10 years. It enables him to exploit the creation commercially and in case of infringement, get reliefs permitted under the Act. Now let us come to the infringement of layout design. What does that mean? Only a registered proprietor of the layout design or a registered user can make use of the layout design. What will constitute the infringement of layout design has been explained in detail in this Act. Under the Act, any person who infringes the layout design shall be liable to pay the proprietor of the registered layout design royalty to be determined by the negotiation between the registered proprietor and the person or by the appellate court. Enforcement of exclusive rights. An Act expressly lays down provisions affording criminal remedies for the infringement of a layout design. So not only civil remedies, there are criminal remedies also. But the Act does not provide expressly for civil remedies, as in other IP laws, nor does it bar these remedies. That means we can also go for civil remedies. It merely refers to damages in section 16, which says, no person shall be entitled to institute any proceeding to prevent or to recover damages for the infringement of an unregistered layout design. So if it is not registered, nobody can apply. But if it is registered, it can apply for the protection of, for the prevention of infringement or for the recovery of damage. That means what? Civil remedies are also available under this Act, though it is not expressly provided. Therefore, it can safely be said that the civil remedies such as injunction, accounts of profits, damages would be applicable to enforcement of the rights with respect to layout design as well, as in the case of Patents and Copyright Act. Now let us come to the criminal remedy. Therefore, whoever knowingly or willingly infringes a layout design shall be punishable with imprisonment up to 3 years and or a fine between 50,000 to 10 lakh rupees. In case of infringement, the registered proprietor is required to submit a written complaint to the Court of Judicial Magistrate First Class, which can take cognizance of this offence. The court may order forfeiture to government of goods related to the offence, and the same may be destroyed in case of a conviction. Then let us go to the next one. The Act exempts from liability innocent purchasers of infringing cheap products with respect to the importation or distribution of those products before they had notice of the layout design protection, provided they pay the proprietor of the registered layout design a reasonable royalty. Now, whether rights under this particular Act can be assigned or transmitted or registered to the registered users, or whether it can be transferred. Okay, a registered layout design can be assigned or transmitted whether with or without the goodwill of the business concern. An assignment of a layout design must be made in writing by a registered proprietor. No specific form has been prescribed for this. Transmission means transmission by operation of law, devolution on the personal representation of a deceased person, and any other mode of transfer not being an assignment. Exploitation of integrated circuit design without registration. Act allows the exploitation of a protected layout design without agreement of registered proprietor by the government or by third persons authorized by the government in public interest. So if there is a public interest, then there is no need of any kind of registration, or if it is registered, the government can take over the rights of the registered proprietor. Government may exploit the protected layout design without the agreement of the registered proprietor, to whom an adequate remuneration would be paid. For example, if the nation is engaged in war and it requires the use of a specific integrated circuit to incorporate into its latest long-range earth-to-earth missile, but this integrated circuit consists of a protected layout design, then the option available to the government are to enter into an agreement with the registered proprietor of such registered layout design, or on commercial terms for the permitted use of the layout design, or to approach the appellate board to permit compulsory usage. So in the end, we can say that the enactment of this Act fulfills India's obligations under the TRIPS agreement, as the Act fulfills the TRIPS norms. This government initiative to protect integrated circuits will build confidence in the industry and global investing community. The Act compares well with overseas enactments in all important aspects, at times going further even. For example, requirement of inherent distinctiveness and provisions of criminal remedies for infringement. India itself is slowly emerging as an important player in the multi-billion-dollar global semiconductor industry. So with these few slides, I would like to conclude. Thank you so much for being patient. All the best to you. I'll see you in my next class. Bye. Bye-bye.